Yeah, Bill Henshaw here, Constitutional Crisis Channel, your constitutional kook hard at work. Another recent event, some of you may have seen this, this just was recently decided in the case out of Ohio called Husted v. Randolph, and it involves the Supreme Court sustaining the Ohio practice of purging quote unquote infrequent voters from voter registration rolls. Now, they got a good long opinion on this case, not like the Colorado Baker case that was 5 pages per curiam. This one is about 85 or 90, and it's a split opinion, meaning that you have a majority opinion and a dissenting opinion. Now, I've only scanned them at this point, but you can be damn sure that they never reached the real issue here. Because my immediate reaction to that, given what I know and what I can prove and my record over the course of 4 decades, my question in this case would have been to the Ohio Secretary of State, what voters is it exactly that you're purging? That's all you have, just as we have in California and everywhere else, is citizens who signed a voter registration form under penalty of perjury that they owe their citizenship to the non-existent 14th War Amendment. No citizenship, no voters, no electors, no electoral college, no president. So to the Secretary of State in Ohio and the one out here in the territory of California, what voters exactly is it that we're talking about? And what elections is it that we're talking about? Because you can purge them all. It doesn't matter a whit, because in territories you don't have elections. All territorial officers are required under Article 2, Section 2, I believe paragraph 3, to be appointed by the president and or a territorial governor appointed by the president. That's how it works in a territory, and I can personally guarantee you that Moonbeam Jerry Brown in Sacramento isn't a territorial governor. I've asked, they provided no response. There's nothing to say. They can't prove it. One of the reasons, by the way, I'm going to be issuing subpoenas now in one of my packets and send subpoenas literally to the governor, the secretary of state. Produce the certificate of your appointment by the president. If you can't do it, you ain't properly in office. See you later. You've got no authority. Who the hell are you? Haven't figured it out yet. That's the sort of question I would love for the justices to have gotten to, and they didn't. Not even the so-called conservative wing with Sam Alito, with Neil Gorsuch, the Chief Justice, John Roberts, Clarence Thomas. I mean, none of them got to that question. I'm going to scan that. I'll be looking at the dissent carefully, but you can almost be damn sure you're not going to get any questions of this type mentioned in this case. That's how the system works. And you have to understand that. This court has its own self-promulgated rules for status and standing. It's the Ashwander case. Send me an email about that. I will send you information on Ashwander. Send an email at ccaspari@live.com, and you read the court's rules, and what does it say? I hand to God exact quote. The court will not address an issue of constitutional law, though properly presented by the record, if there is also present some other ground upon which the case, not to mention the creator endowed inalienable rights of the victim, can be disposed of. And I think all of us today know how great the government is at disposing of things. So if they have any reason to get around it, and that can be a simple application for benefits under social insecurity, they will not answer the question. And they know, by the way, the members of the Supreme Court bar, some of whom may actually know these issues, have at least an implied agreement not to raise them. You're not going to get them to do it. And they don't teach us in schools. They didn't teach me 50 years ago. They ain't teaching you now. If we don't know, how can we possibly do it? That's why I put 4 decades into my life, going on 11 years all in, to be able to do that and to make it much easier for you to do it by getting my document packets and filing documents and going in and winning your cases, because the DA, the dumbass, isn't going to know how to answer them. That's the whole point here. So that said, more information on this when it comes up, and I will reread the opinion. If I find anything different, I'll let you know. Thank you.